Hello, hello. Good morning. Ara? हेलो हेलो बस हाँ वो लेट होगा ना दीपक जरा तो इधर आ जाओ पास वाले को बता अंदर जैसे पहली तू गए जी होता है em không có sẽ hình đấy em không có sẽ hình pasti itu whisky kamu masyarakat cinta mau dari tidak itu lalu itu dia akan ini nih kan coba buat ini kan yang gila yang benar yang lalu mungkin mungkin nanti sendiri yang boleh macam cerita ini kali berarti kita lagi ini announcement dari saya terus yang mana aku delay होना चाहिए ना जल्दीबाजी नहीं चाहिए आगू भी ini yang jalan ini kita nak macam pada itu dor lagi kali ini mesti dor lagi biar pun yang benar अभी have to apply the Hmm. Jadi dia tarik sebenarnya sampai orang yang segini terus ada tambah itu bisa kenal orang cari paling Fuck. Part Anu bulan baru tidak ada ah hmm.
Officers at the back, please. Last, come forward, sir. We are about to begin our program, so I request all the participants to have your phone on silent mode and refrain using during the sessions. Thank you.
देखो ना मशीन डिलीवरी का तो डिलीवरी घर में दुकान
Good morning. I request Honorable Justice Dinesh Mahesi Saab, Judge Supreme Court of India, Honorable Mr. Justice Sandeep Mehta Saab, Administrative Judge and Chairman of Rajasthan State Judicial Academy, Honorable Mr. Vijay Bishnoi Saab, Judge Rajasthan High Court and Chairman Working Committee of RSA, Honorable Dr. Justice Pushpinder Singh Bhati, Judge Rajasthan High Court, and respected director, sir, to adorn the dais. Sir. Thank you, Lordship. Honorable Mr. Justice Dinesh Maheshwari Saab, Judge Supreme Court of India. Honorable Mr. Justice Sandeep Mehta Saab, Administrative Judge Rajasthan High Court and Chairman of Rajasthan State Judicial Academy. Honorable Mr. Justice Vijay Vishnoi Sahab, Judge Rajasthan High Court and Chairman Working Committee RSJ. Honorable Dr. Justice Pushpinder Singh Bhati Sahab, Judge Rajasthan High Court and Honorable Judges of the Rajasthan High Court. Respected officers of the Academy, invited faculty, and esteemed participating judicial officers from Bangladesh, a very good morning to all of you. Dr. B.R. Ambedkar, the father of the Indian Constitution, once said, "The cultivation of mind should be the ultimate aim of human existence." Carrying this aim in our hearts and mind, today is an honor itself to honor this beautiful gathering. I, Govindram Meena, Deputy Director, on behalf of Rajasthan State Judicial Academy, welcome you all esteemed participating judicial officers from Bangladesh at this Judicial Academy for this 5-day training program. Moving towards this traditional auspicious ceremony of lighting lamp, as a tribute to Mother Saraswati, the goddess of knowledge, I would sincerely request the Honorable Dais for lighting the lamp, sir. Thank you, Lordship. Following the respectful tradition of acknowledging our guest, I am profoundly delighted to take an opportunity to invite Honorable Mr. Justice Sandeep Mehta Sahab, Judge Rajasthan High Court and Chairman of Rajasthan State Judicial Academy, to present a planter to Honorable Justice Dinesh Maheshwari Sahab, Judge Supreme Court of India. Thank you, sir. In this series of welcoming, now I invite Honorable Mr. Vijay Vishnoi Sahab, Chairman Working Committee RSJ, to present a planter to Honorable Mr. Justice Sandeep Mehta Sahab, Chairman of Rajasthan State Judicial Academy, sir. Continuing further this welcome series, Honorable Mr. Justice, to welcome Honorable Mr. Justice Vijay Vishnoi Sahab, I would like to call upon respected Mr. Ajit Ahmed Bhuyan, Senior District and Session Judge, District Chattogram from Bangladesh, for presenting planter. Thank you, sir. Along the same line, to welcome Honorable Dr. Justice Pushpinder Singh Bhati Sahab, Judge Rajasthan High Court, I would like to invite Mr. Mohammad Usman Haider, District and Session Judge, District Feni, Bangladesh. Thank you, sir. Now I invite Mrs. Najmun Nahar, Joint District and Session Judge, Gazipur from Bangladesh, to present planter to respected Director Kamal Changani, sir. Thank you, ma'am. We are deeply honored to have you all here, sir. Thank you. Proceeding further, it's my honor to invite Honorable Mr. Justice Sandeep Mehta Saab, Administrative Judge, Rajasthan High Court, and Chairman RSJ for welcoming address. Sir.
My Lords, Honorable Justice Dinesh Maheshwari Saab, Judge Supreme Court of India. My esteemed brother, Justice Vijay Vishnoi. My esteemed brother, Justice Pushpender Singh Bhati. Honorable sister and brother judges, Director Judicial Academy, Shri Kamal Changani, officers of the Academy, and participating judges from Bangladesh. It gives me immense pleasure in welcoming my Lord Honorable Justice Dinesh Maheshwari Saab to his own academy. My Lord has been and shall continue to be an integral part of this august institution, the Rajasthan State Judicial Academy. He has had association with the academy from the days when the trainings were given in different places because we did not have this magnificent infrastructure. It is with his toil, putting in his sweat and blood, that this fantastic building in which we are holding this training program has come up. His lordships had such a deep involvement in the affairs of the judiciary, of the Judicial Academy, that he would, after completing his court hours, continue to monitor the construction of this building with minuscule details and taking pains to select every single stone and every single tile. I would like to share with the officers from Bangladesh that in the training sessions which my lords used to take, after the faculty members had completed their session, the roundup or the mop-up of the discussions which were held in that session would continue to longer periods than the original period, only original session. And with his lordship's deep involvement with the officers, we are having wonderful officers, the batches right from the years 2011 onwards, and the batch of 2013 district judges, some of whom would be sharing their immense knowledge with you during the course of this training program. His lordships is a walking library, an audio encyclopedia. No words of accolade will suffice to define his legal acumen in this short span of time. In addition thereto, his lordships, even after having left the state of Rajasthan, even though he left the state of Rajasthan somewhere in the year 2014, he continues to have interaction with almost every judicial officer, not only judges, every judicial officer of the state of Rajasthan. You put him a word, put him a name of the judicial officer, and he will give out the complete details, how the person was selected, what kind of training he did, where he was posted. That is the kind of interest and dedication to the institution which ensures its appropriate upbringing. We are deeply obliged, my lords, that you have shared your invaluable time to be amongst us, because this has been the experience. You just put a call that academy needs my lords, and he is here with his valuable time, with his valuable thoughts. Thank you, sir, from the core of the heart, for having nurtured this academy right from the time of the foundation stone laying, and in continuing to do so forever. We wish and desire that your involvement and the blessings to the academy will be perennial and forever. A very warm welcome to Honorable Justice Dr. Nupur Bhati, Justice Yogendra Purohit, for their first interaction in this academy in a training program. Of course, they have participated as participants, but today we welcome you for the first time after having been elevated and adorning the Rajasthan High Court. Welcome, Madam Bhati, and welcome, Purohit Sahab. A very warm welcome to the officers from, judicial officers from Bangladesh. This is probably the second batch we are having. Recently, we had a West Zone regional conference of the NJ in Jodhpur, and moment Director Sahab, Justice Sahi, had a look at the infrastructure and the other facilities available in the academy, he immediately conveyed that when the batch of the Bangladesh judicial officers is coming, judges is coming, he would like to have one of their training sessions in the academy. And of course, we are always open to these kind of wonderful suggestions. And I readily agreed. And here you are in the sun city of Jodhpur, which is just 275 kilometers away from the Sonar Bangla. I'm sure even the earlier batch which came, they had a very keen interest that if it is possible, please arrange us a meeting, a visit to the Sonar Bangla. But because of your travel confines, it is not possible to do so. Even this time around, I requested Justice Sahi that if it is possible, please spare one day and we can plan a trip. Let us see if something fructifies. A very warm welcome to you. I'm sure that your visit to Jodhpur and the Rajasthan State Judicial Academy will add to your acumen, to your wisdom immensely. Jodhpur and the Rajasthan High Court have had a wonderful tradition. We have provided wonderful academicians, honorable judges in the Supreme Court, chief justices all over the country. My Lord's Honorable Justice Maheshwari is with us. We have had Chief Justice of India, Justice R.M. Lodha, who was from Jodhpur. We have presently Honorable Justice Dalveer Bhandari. He is serving the International Court of Justice. He is from Jodhpur. So I'm sure that your visit to Jodhpur, and more particularly the Rajasthan State Judicial Academy, will prove very fruitful. I wish all of you a wonderful interactive training schedule. We have designed the 5 days module in a manner that some from you will share the experiences from Bangladesh so that we can also be enriched by your experiences. Once again, welcoming you in this sun city. I hope that this training session is a great experience for you. Thank you. Jai Hind.
Thank you, Your Lordship, for setting up the tone of this training program with that inspiring speech and a warm welcome. In order to quench the thirst of knowledge, finding out the path to right and getting wisdom and knowledge, now I would like to request Honorable Mr. Justice Dinesh Maheshwari Sahab, Judge Supreme Court of India, for delivering the keynote address. Sir.
इसको रखने की जगह से Okay. Thank you. A very good morning to all. Brother Justice Sandeep Mehta, Administrative Judge, Rajasthan High Court, and Chairperson, Rajasthan State Judicial Academy. Brother Justice Vijay Bishnoi is Judge, Rajasthan High Court, and Chairperson, Working Committee, Rajasthan State Judicial Academy. Brother Justice Pushpendra Singh Bhati, Director, Mr. Changani, my colleague judges of Rajasthan High Court, and judicial officers, and above all, the center of attraction for this day and the coming days, my respected judicial officers from Bangladesh. I'm sure with you having undergone first round of your training in the wonderful settings of the National Judicial Academy at Bhopal, you are keenly looking forward for this second leg of your training here in this historic city of Jodhpur with Rajasthan State Judicial Academy. I was asked to say a few words to set the ball rolling for this second leg. Of course, since you are already undergoing the training, you have already completed first leg of it. There's nothing like inauguration as such, but a few thoughts which I intend to leave for you to ponder over for next few days, and of course for all times to come as during your services to your respective jurisdictions as judicial officers in Bangladesh. Before I say anything else, I may assure you that Brother Justice Sandeep Mehta has given a kind of a warning or threat to you that after sessions, earlier days, after certain sessions were over, I used to jump later on, and then the mop-up sessions would get elongated or extended even beyond the time or much more than the time which was taken by the main session on the original session. I can assure you that so far as today is concerned, I can't do like that for the simple reason that there is a time limit and I have to close whatever I have to say within the given time. So please don't worry about any such kind of a problem coming up for you. Friends from Bangladesh, before me saying anything else, let me tell you how much this city, particularly, most of you must be visiting this city for the first time. How much this city has the connect with your country known as Bangladesh. 1971, of course, you must be aware of, you are aware of the history of making of Bangladesh. Making of Bangladesh had its own trials and tribulations before Bangladesh got its independence. And of course, the world has traversed along since 1971. But that beginning of 1971, there was a thick of activity, the activity which, of course, otherwise all human beings would wish and pray that they do not happen. That is called war. That's called conflicts. That's called disputes, and disputes leading to loss of life, property, and even the confidence, shaking the confidence of the people. Be that as it may, 1971, the younger generation might not have been even born at that time. But why I'm saying that connect of 1971 with Jodhpur is this. When that war, unfortunately, took place, the month of December, we distinctly remember, 1971. If I remember correctly, 16th December or 17th December was the day when Bangladesh got its independence. From 3rd December to 16th December, there was a lot of activity at both the fronts. The eastern front of India, where lies today Bangladesh, and the western front, where lies Jodhpur. We were school students, at least my age group people. We were school students. Those were the days when Jodhpur was a hub of activity because of that war, because of that particular war, because Jodhpur was the western command of the Indian Air Force. And being very near to the border and bordering our neighboring country, there was a thick of activities. We grew up as students maybe secondary, higher secondary classes of students. We grew up having seen two wars, 1965 war. Of course, you were not connected at all with that, but 1971, when India was thickly involved in two fronts, on the western side also and the eastern side also. So Jodhpur remained always in thick of activities, and we were just at that particular point of time wondering, as of course as school kids, as to why this all is happening. What is the idea? But slowly the understanding developed at all places, and we understood that it was the call of humanity above all. It was not a call of borders. It was not the call of one person or two persons. It was not a call of any religion. It was not a call of any particular class. It was the call of humanity that India responded. And India responded decisively. And that is led to ultimately birth of our one of the most friendly neighbors, Bangladesh. Down the line, leaving that story aside, when we grew up, after a lot many decades, I had the chance to serve the state of Meghalaya as the Chief Justice of that state, which is another state bordering your country on the other flank. And it was very interesting to see there how much of connect we have, rather how much of gelling we have, as people are wonderstruck with the strange kind of boundaries we had, and for uh, years and decades, those kind of boundaries, or rather undefined boundaries, existed. The enclaves and the exclaves, the uh, boundaries within boundaries, where you will find, and it was a great study for several of the geography students also, and how it is happening that, well, there is a particular area which is India, and within that India is some area which is Bangladesh, and within that Bangladesh there is another area which is India again. And that is what the enclaves were. Of course, over the years, later on, 2015 or so, a lot many those boundary issues were decided. A few things still remain. But the beautiful part of that kind of undefined boundaries had been that we as societies together, we as human beings together, we have shown that these lines on the map, these lines on the globe hardly matter so far as our connect as human beings is concerned. And that is how India and Bangladesh had always been prospering. I was for 2 years there in the state of Meghalaya as Chief Justice. I could really wonder when you are strolling around, when you are in India, and when you are stepped into Bangladesh, and when you come back. Well, and there was the local populace. They were hardly bothered with whether it is India or Bangladesh. For them, well, the Mother Earth was always there serving them. It has been those ethos we all have grown up. And it's compliments to our Judicial Academy, as also the compliments to the respective governments, that in these exchange programs, you are here sharing the experiences of the judiciary in India, which, as you all know by this time, that the fundamentals are the same as we all got it from our colonial rulers at that time. But over the years, the things have developed, but the fundamentals have always remained the same, be it the basic concepts of criminal law, basic concepts of civil law, basic concepts even of the fundamental constitutionalism also. Basic concepts of evidence, basic concepts of laws of procedure, basic concepts of the laws of all substantive laws. So there, Well, this particular training program, and if I understand it correctly, well, the batch of the officers of Bangladesh here consist of the officers of all grades, different grades. So it's going to go a long way. I had a few opportunities when I was in the state of Meghalaya, having had long discussions with the judges of Bangladesh who were come visiting there. And it was always a learning experience to share our experience, our thoughts, to share our common factors, as also to understand where are the divergences and where do we again converge into. So, friends, that way, well, I would expect all of you utilize your time in this historic city of Jodhpur, which, although on the far western side from your country, had always been right from the beginning, been having a great connect with Bangladesh coming up, and those connects have continued for all the years. Those days when uh, several settlements, several people, distressed people rather in need, were required to be settled. Jodhpur was also one of the cities where some of the people from Bangladesh came and settled and were allowed to be settled by the governments. Anyway, these are not at present today's our part of discussions. The only point I was making was that this city has lot many for you to offer as regards history. And coming to our judicial functionings, as Brother Justice Mehta has indicated, this city has provided growth to the judicial systems, not only in the state of Rajasthan, but to the country also, not only by the contribution of some of the persons holding particular positions. The fundamentals remain that here is this city which houses the seat of the High Court of the state of Rajasthan, though not being the capital otherwise of the state of Rajasthan, has its own contribution in the growth of jurisprudence. And I'm sure sitting in this environment all over here, of course, Brother Justice Mehta would indicate that I had a little contribution in the coming up of this academy, but I can assure you that this academy, the setup which you see today, and it's going to grow further, had never been the work of any individual or any particular person. There had been, as I was just sharing with my colleague judges, there had been uh, right from the beginning, right from the day when this academy was conceived and it was developed, the honorable judges, our seniors also, my judicial officers who had worked with us, and it had been a continuous journey. It always goes on. And what lies in the fundamental of it is that this academy and all our academies, they always work on the concept of we. Nobody, nowhere it works on any concept of I. There is no I here. Everybody's I, well, gets here mingled into, gets here dedicated to the we of all of us. So, welcome to all of you, friends, and thanks to the Judicial Academy having given me an opportunity to have a few words with you to begin with this training program. Friends, training as such was also not to begin with when judicial systems were put in place. Training as such came as a concept very late. Of course, sporadic training or to began with some kind of an induction instructions, if I would say, were being provided to the judicial officers of the yesteryears, where there was some of those judicial officers now on the bench of Rajasthan High Court. Some of them are here. They would testify to it when they began their career. There was no such thing like training as such. But over the years, it was felt, and thereafter it was clear to everybody that, well, to become a meaningful judicial officer, something more than our knowledge of the laws, whether substantive law or the procedural law, even our knowledge of jurisprudence also, something beyond that is needed. And that what is needed is our capacity building, our personality being developed into or transformed into from a good academician or a good intelligent person or a meaningful student to that of a person who delivers justice. When delivery of justice is the concept, well, the personality needs to be different, and all these training programs have always been modeled, have always been designed in the manner where it's not the concept that, well, anybody would be teaching you anything or it would be a coaching class kind of a thing. But since you all are, as we understand, you all are serving judicial officers, that presupposes that you have fundamentally done with your subjects. You have that proficiency over the subjects. You are dealing with your courts also. So there is nothing like teaching or nothing like coaching on any particular subjects. So far as queries, doubts, disputes, queries and doubts and inquisitiveness is concerned, that will always remain in all of us. We are into a job where every day there are questions, every day there are issues to be framed, every day the issues to be answered. But then while dealing with that, we all keep on reminding ourselves that what we are doing in our job as judicial officer is not a mere academic exercise of merely writing a judgment or merely writing an order. Our every action or every dealing correlates with the people who are looking for the delivery of justice in our court or in our jurisdictions, whatever jurisdictions we are holding. Dealing with the people, dealing with the public, and delivery of justice requires a concept where you mold yourself into the objectivity to the maximum possible. This ultimate objectivity would always have its own questions because we all are human beings. We all have our thoughts. We all have our concepts also. But how to shun off some of our concepts while dealing with a matter before us, how to look beyond the lines which are beyond the prints which is presented to us, how to look ultimately to the destination justice. That is what the concept of all these training programs has been, friends. So I would definitely wish all of you to utilize this time for enjoying this wonderful city of Jodhpur, enjoying this wonderful country, India, having so much of connect with your country, and at the same time, well, enjoy yourself in enhancing your own capacities in these training programs. So when you go back holding your respective jurisdictions, holding your respective courts, well, your approach, your outlook will has a marked empowerment or marked enhancement, which I'm sure is going to be the result of this training programs, these kind of training programs. Friends, a few quick words I wanted to share as regards how do we go about in these training programs. How do we look at anything which is presented to us and how best we will receive out of that, or whatever we receive, how do we develop for our own betterment? That is what for a trainee, every trainee officers, I had always been saying, be inquisitive, always ask why of anything rather than only asking what or how of anything. What maybe is known to you. You already studied your law. You have already studied your briefs also. But then, friends, it's the study of or the regular concept, regular conceptualization that we as permanent regular students of law, we will always remain students of law. We, whenever we look at anything, whenever we try to understand anything, whenever anything is presented to us, any concept, new or old, whatever, we look at not only the concept, we look at not only the letter of law, but we try to look at and we try to ask ourselves the question, or maybe anywhere where we can ask that question, why of anything? It's like if I can give you an example, a few examples, like uh, a if few things are provided where certain things are do, certain things are don't, certain things are to be done. Like I'd been asking a question always to my judicial officers, that when you look at the civil procedure, you have all the concepts as to how you will go about, and I see more or less the code of civil procedure which all of you are dealing is the same concepts are there as your Indian counterparts are doing in the code of civil procedure. But then in that concept of that procedural law of code of civil procedure, you have the concept of judgment, and then you have the concept of decree. Then what is a decree? If I ask you, or if anybody asks you, well, anybody of you, whether it is a young judicial officer, new entrant, or a very fairly senior district judge, anybody would be able to answer it. So what is a decree, and how the decree is made, etc., etc. But then do we stop and ask ourselves that if there is a judgment which is otherwise self-contained, which contains everything, why do we need a decree at all? If we ask ourselves, if we pause and ask ourselves this question as to why a decree, then different answers crop up. We had been attempting these questions and these answers in our training programs for, of course, hours and hours. Justice Mehta would indicate that I had been spending hours. But these were those questions of why. When we ask ourselves this kind of a why, then we find that, well, there has to be some purpose. Then when we look at the purpose, is it the purpose that, well, there has to be a summary of the judgment? Then we can give an answer that it is not necessary. Is it the purpose that it is just the execution that the decree is needed? Then we find that, well, without decree also the execution can be made. We go on looking at the answers as to why do we need a decree, and when we arrive at a clear-cut answer to that question of why, then we find that several concepts underlying decree, several concepts behind the decree or beyond the decree, both, well, all, I mean, they come clear to us. Similarly, when there are certain setups, like in your criminal law also, there are certain setups when you look at the procedural law, code of criminal procedure, more or less akin to, but there had been several refinements made in India, of course, after Code of Criminal Procedure 1973, which substituted its forerunner 1898 CRPC. Then we find that apart from the procedure for how to go about a particular criminal case, a criminal complaint or an FIR, and then having the charge sheet filed, charges framed, trial done, judgment delivered, all that being there. But then we pause and then we look at the entire setup of the code of criminal procedure. We find that some very interesting features are there, like the features of certain provisions which are meant for, well, say like the provision for maintenance of a woman, like the provisions for maintaining the peace and tranquility, like the provisions for avoiding obnoxious stopping of obnoxious industries, or the provisions like holding somebody only to give a bond for good behavior. We need to pause again and ask ourselves a question, friends, that if these areas belong to substantive law, then why they are in the procedural law called Code of Criminal Procedure? These questions, friends, what I mean to say is, well, go a long way in clearing a lot of doubts also, redefining and refining our thoughts also as to what is the entire setup, as to how these things were conceived and then put into the statute book, and then how do we go about, and thereafter when our concepts of why are clear, and I'm sure in the coming days you are going to be benefited with the learned faculties who would be interacting with you. But I would request all of you to keep on troubling yourself with why of everything rather than merely taking down or taking note of what of anything or how of anything, because that what is always there available. So far as information is concerned, friends, it's not only the books that the information are available. In fact, information is now available in abundance and at the click of the button, or well, the moving of the fingers. You got so many of the features available so far as taking of information is concerned. But for us, the judicial officers, what is required is making sense out of that information. You have a lot many, say, precedents cited before you. You have a lot many things pleaded before you, as you all, as judicial officers. When you have a lot many things stated by a witness before you during the course of your trial, what you do is that out of that entire cargo which is presented to you, out of that entire thing which contains relevance and irrelevance both, which contains so many things which need to be sifted through, you as judicial officers, you have been doing and you would always be doing, well, making sense out of that information. As you know, as when you are asked to frame the issues for the trial of a civil suit, what you do is, well, you frame the issues with reference to the material propositions of law and fact. Now, the key words are material proposition. So there would be immaterial things. There are bound to be. There are likely to be immaterial things. You will be, well, removing that immaterial part out, and then, well, framing the issues with reference to that material aspects of facts or law. That is the training of a judicial officer. That is the training of your judicial mind. But then, how do you quickly sift through and distinguish between material and immaterial, relevant and irrelevant? That is where, well, your capacity building always helps, and that is where, well, your ultimate delivery of justice, that helps. Friends, these training programs are meant for those purposes. There are several such features, several such things for you, which you can, utilizing this time over here, you can inculcate, you can ponder over, and see the beauty of law, means framing of the law, and how you can take it further. I give you I give you just one example. And if you will find time to study Constitution of India, you'll find fundamental rights. So many things are talked about fundamental rights, and they are all fundamental to everything. They all relate to basically basic human dignity, if we put it in one bracket. But basic human dignity, ensuring it were against exploitation or against discrimination by the state or even by any other person. Well, dignified life is one thing, but then when you look at something like Article 32 within the chapter of fundamental rights, what you find is that whenever there is a violation of fundamental right, when you have a remedy available, that remedy itself has been assigned the status of a fundamental right. Friends, we as students of law, we know it that merely having a right, and this is how our training of civil law goes, that merely having a right is not sufficient for a person to come to the court, means to be having finally a judgment delivered in his favor, his or her favor in the court. Having a right is one aspect. A violation of that right is another aspect which gives him a cause of action. But these two aspects are also not sufficient. That may give you, well, disputants only when one person is asserting his right and another person, and he says that my right has been violated by the other person, plaintiff and defendant, if you put them loosely or broadly like that. There is another fundamental feature required, and that feature is right to relief. A person can become a plaintiff in a civil court not merely by having a right and not merely by suggesting that his right has been infringed. He need to have the essential feature that he has a right to relief also from the court. That right to relief, well, once we are clear on the right to relief concept, all the conceptions of Code of Civil Procedure starts becoming more clearer to us. That a person need to have a right to relief. Reverting to what I was saying about Article 32, that right to relief as regards violation of fundamental rights, that itself has been assigned the status of a fundamental right, and that is how you find Article 32 being placed in the same chapter which is called the chapter of fundamental rights. When this is one of the unique features of Indian Constitution, that right to relief as regards fundamental right itself has been assigned the status of a fundamental right. These kind of features, well, they are for all of us to understand and then develop on them as to how far we can take so far as delivery of justice is concerned. Well, there are unique features then, something like Article 142 in the Constitution of India, which gives to the Supreme Court an extraordinary power to pass any order, well, so as to, well, ensure the justice to the cause. That kind of a provision, that kind of a power is otherwise not given to any other court, be even not even to the High Court also. But then why that is there? Why this kind of a power is given and how it operates? These wise friends, I'm sure, are in the coming days going to help you refine yourself, help you develop in your thoughts. There are several other features like so far as the working of the Constitution is concerned. I'm sure you must have in your first session of first leg of your training in National Judicial Academy, you must have come across, you would be coming across here also, that our Constitution in the working and developing on several different areas, including, well, expansion of the concept of, well, right of life expanding it to, well, provide for everything like food, water, decent environment, everything related with the right of life, expansion of Article 21, and then expansion of even our jurisdictions by way of public interest litigations. We contrast that with what has been already provided in the Code of Civil Procedure by way of class actions with reference to something like Order 1 Rule 8. You need to then correlate as to how the class actions were conceived, even in the provisions which were made much before PIL was conceived. But then limitations on that as to when you do the study of the provisions like provisions like, I'm sorry, Specific Relief Act, well, which provide for specific remedies. Again, relief, it is very interesting expression, specific relief. It is contrasted with common relief. Well, common law relief and then specific relief, then you find that, well, there are certain reliefs which are provided, and you contrast them with the common law, you find that, well, there is a contract, and if a contract is otherwise violated or breached, the common law remedy is you have your damages. If a person has breached a contract or has violated a contract, well, whoever has suffered any loss have your damages. But then there are certain kind of contracts which would be otherwise enforced by the court. Forget about the damages, the contract itself has to be enforced. But there also a proviso, and that's very interesting, like when you look at section 14, that the court will not be, apart from other things, court will not be enforcing a contract which requires a regular supervision by the court. Now, that was required to be provided, that otherwise the court is not meant for, that is what the concept had been. The classical court, the regular civil court is not meant to go on supervising that when we ask for a particular contract to be performed, then if the contract had been for, well, giving a performance on the stage, say, before you, and if I decline to perform that particular contract, then if the court enforces, and then whether I have been bought here or not, and I have been making performance, I am rendering the performance or not, the court is not supposed to be doing that. So court would not be doing that. Regular supervision. But then, friends, contrast it with the concepts developed by the constitutional courts like continuing mandamus, where we issue a mandamus, we ask a particular authority or body to do something and do not leave it there only. That particular jurisdiction, a different jurisdiction, providing for continuous mandamus by the constitutional court. Now, a constitutional court, like you will come across several such decisions where the Supreme Court orders after orders after orders made, like T.N. Godavarman is one of the very classical example. Anybody would be, well, sharing with you. You would also be knowing about it. That environmental protection. So it is not one day affair that we have issued an order and it is over. It's a vast country, vast requirements. Then you do something and then report back, and when you report back we find something more to be done, well, we ask you to do more, then we go on issuing mandamuses. So the continuing mandamus was a concept developed, but study it, correlate it with otherwise the classical law of the specific relief, where the court otherwise will not be issuing an order or a decree enforcing a particular contract, but then how these things have developed and why these have developed. Those studies of why, friends, is going to go a long way in defining, again, I would say, in giving you more clarity over all the concepts. One of the areas, friends, I always tend to underscore as regards with our judicial officers, that all said and done, so far as dealing with the matters are concerned, particularly, this is particularly in relation to civil law or the civil jurisdictions. Because in the criminal jurisdictions, most of the time what happens is that when after you have delivered a judgment, say a classical criminal case, you have delivered a judgment, rendered or awarded a particular punishment, thereafter, that execution part well goes out from the court. It goes to the state. Then it is the lookout of the state to ensure that if you have awarded a particular person, say, a punishment of serving an imprisonment for 5 years, say, for example, thereafter, it is the responsibility of the state to make it sure that the person is in prison for 5 years with reference to the rules as to how he serves it out. But so far as the civil jurisdictions are concerned, a lot much is required to be done on the part of the court to ensure that you are not only delivered a judgment, you are not only, well, passed a decree. The decree is finally, ultimately reaches to its logical conclusion. The person gets the fruit of the litigation. Now, that fruit of litigation, the requirement of execution, what happens is, and this is where we all judicial officers need to ask ourselves and need to be always remain on alert mode. Sir, while dealing with friends, civil suits, or whatever kind of even interlocutory applications, etc., you make it sure that, well, you, with all clarity, you apply the law to the facts of the case and you deliver the judgment. A decree is also passed. But when it comes to execution, or that zeal, that enthusiasm, that alertness, and the involvement which we otherwise show to a regular matter until the delivery of judgment or decree, well, somewhere we have to ask ourselves that that kind of an alertness is not reflected when we are dealing with execution matters, because execution matters perforce, because of the rules which are provided for execution, they somehow, for all of us, for the judicial officers particularly, there are certain such features which tend to create more of questions before us, much more of the questions rather than the questions which were there while we were dealing with the suit or delivering the judgment. What happens is that in that process, if a person who is not interested in that decree to be executed, well, he would be, if we are not very sure about how to go about a decree, how to have it executed, any person who is not interested in having the decree executed would be utilizing any kind of such kind of a shortcoming on our part for his advantage, which would be to the disadvantage of the interest of justice finally. We need to then understand the concepts. Once we understand the concept of the law of execution, that itself is a wonderful study, when we find that these are all methodical scientific rules, the only requirement for all of us is to just sit back, relax, and, well, redefine ourselves, have a relook at the principles of execution. And once you will find that, and then you need to remind yourselves again and again. There are certain very interesting quotes, but, well, I'm not taking your time on that. What I wanted to say is this, that merely delivery of judgment, barely passing of a decree will never be sufficient so far as the respect of rule of law is concerned, so far as adherence to rule of law is concerned, unless you means the court ultimately is able to ensure that whatever is intended of by that decree ultimately is brought about. Whatever fruits are intended to reach a particular person, they do reach. And that is where, because courts are respected, not, not only, we are talking from a commoner's point of view, talking from a point of view of a person who is otherwise has got no knowledge about what well, legal juggleries we all do. He is interested about the person concerned, the disputant or the litigant is concerned about ultimate fruits. That person, well, would be respecting you and the system and the court and the justice delivery system, not for your great learning and an erudite scholarship depicted in your judgments, friends. That is needed, of course. That is needed for various purposes, including the students of law, including your appellate courts also, including, well, anybody to understand. But then, so far as the person in need of the final fruits is concerned, his respect is dependent on your ensuring those fruits. And that is why, well, in several jurisdictions, we have evolved the procedures of contempt also. Even when you pass something like a temporary injunction order also, there are disobedience provisions, and then when you contrast them, you need to again go on asking yourself, how do you contrast a contempt jurisdiction available to a constitutional court, available to the specific court, with reference to a disobedience jurisdiction, which is available to even the trial court that is passing an order of temporary injunction. When you contrast them, when you understand their ethos and their fundamentals, you find that our law on every single aspect has been laid, has been defined with meticulous precision and meticulous details. So what we need to, friends, do is that remain alert and utilize this kind of time on these training programs in the academies to our best. Friends, these days, after when the entire world has been uh, going through last 2 3 years, the trying times of COVID-19, the humanity as a whole has, well, stood against it, and very significantly, it's a great study for everybody to see that, of course, the countries, particularly of Southeast Asia, the South Asia particularly, India and Bangladesh, classic example of that. Despite having so much of challenges, we have been able to deal with those challenges as thrown by an unknown enemy, COVID-19 pandemic. And we have, well, methodically dealt with it. We have come out of that. These kind of trials and tribulations had been there for the humanity to deal with, but it has been ultimately our commitment to ourselves, our commitment to our society, our commitments and our clarity about, well, how to go about, how to, well, look at the life and how to make the life better, how to look for a better tomorrow. That has been a guiding light, that has helped. Apart from all other medications and whatever are needed, that is a different aspect. But then as a society, we have been able to deal with such kind of a challenge. So any other challenge is not of any. At this day, we can say that when we have been able to traverse through the challenges thrown by COVID-19 also, well, any other challenges we are already capacitated to deal with. But we need to remain always on alert mode. In COVID-19 also, our courts have then, well, improvised on so many things which we were otherwise maybe lagging behind, or maybe we are not attending to it. But that is what the beauty of our jurisdictions is. That is what the beauty of our judicial officers and all the persons in charge of the affairs of judiciary is, that whenever there is requirement, whenever, whatever is the requirement, whatever are the challenges, we have dealt with them, we have come clean of them, and we have come better of them. Like the present days, now when we started with virtual hearing, in several of our courts under the force of circumstances thrown by COVID-19. And the present days are the days where that has helped us in providing access to justice to the people in far-flung areas. They are able to reach the court. They are able to even our progression, our progress of the cases, well, has got an impetus with the people not able to, when something like an accused who is not being presented to the court because of variety of reasons, whatever are the reasons. Well, the present, even if the presence is to be marked, it's marked through with video conferencing, virtual callings also. The people are making attendance, people are making arguments on virtual callings. These are the utilization of the technology. Utilization of technology has gone a long way in digitization of the records also. Now the search engines are available to you, helping you quickly, well, traverse through, quickly shuffle across much more of the information. But friends, I will again remind you that having a lot of information may not be decisive of having a lot of information, having a collection of information that may not ultimately serve that purpose, because we have to, out of that heap of information, we have to make sense out of it. We have to segregate relevant from the irrelevant. That is what the beauty of a judicial officer's calling always has been. Friends, there would be a lot many things you would be going through these coming days here in the training programs. I need not dwell on the subjects as such here, but to begin with, when you are here, remember that the jurisdictions in Bangladesh, jurisdiction in India, have lot many things in common. And there I have been requesting everybody, any judicial officer, that apart from all acquiring all the knowledge, enhancing all your knowledges, there are certain fundamentals, please always keep them with you. These fundamentals would always be your guiding light in whatever way you do or whatever jurisdictions you handle. Our legal history, that's there are two subjects which need to be focused, particularly when you are in these kind of training programs, leaving aside all other CPC, CRPC evidence, etc., which you all are doing and you would always be doing all through your life. Legal history, since we share the legal history to begin with, when this entire area, this entire geographical area, which we now know with the names of different countries, maybe at particular points of time for years and years, was an area where, at least so far as the laws were concerned, so far as the rules of regulations of the human conduct were concerned, they were one and the same. Then you will find that whatever has been developed, whether by the colonial rulers earlier, or whether by the princely states earlier, whether by our different kings or kingdoms later, or now with the present day setups. There are certain fundamentals which are common, and the things have developed out of them. When we know, just an example, friends, in our legal history, when we look at, we find that in the earlier times also, so far as the justice delivery was concerned, it was with the human beings developing into different activities, and the ideal concept of dharma, that where nobody would be doing anything wrong, was long back left. They were bound to happen so many things. The courts were required whenever the disputes were there, or whenever there was a call for, well, somebody not adhering to the rules and forcing the person to adhere to the rule was there. Then the courts were required to be there. Some adjudicator was required to be there. Some some body was required to be there who would listen to the disputant and then will decide. Over the period of time, in our legal history, as we find, that 6 different classes of courts came to be settled and established. The gradings were like this. There's a very interesting study for all of us to understand. The gradings were, in our legal history, we find, the first court was the court of Kul. The 6 gradings I give you: Kul, Shreni, Gan, then Adhikrata, then Shashita, and then Rap. Now, this grading is like this, how this grading came and how we have developed on it and we are developing on it. That the first court was the court of Kul. Kul is basically a Sanskrit expression relating to the family. There are basically the disputes arise within the family. The variety of the nature of dispute would be different, but basically they have their origin in the family. The concept was that there would be court of Kul, there would be different Kul, there would be different clans or classes as we understand today. There would be courts of Kul itself, so that what was the concept was that if within a particular clan or within a particular family or a cluster of families a dispute occurs, the persons of that family or that clan are the best persons well versed in and could be entrusted with the task of, well, delivery of justice or resolution of dispute, if we can say. So these were the initial original courts. Today's days also, when we look at whether the mediation exercises or the conciliatory exercises or these kind of concepts, we look at what will have some elders of the family involved and get the things done, something like that. But then earlier days in our legal history, we find the first original court was the court of Kul. The second court was the court of Shreni, and that was very interesting. That Shreni used to be the courts of the persons of the same profession, persons of the same calling, persons of the same business. Because those Shreni courts were when there is a particular class of business, a peculiar class of dispute will arise with reference to that particular dispute. The dispute which arises, say for example, in a real estate business, and a dispute that arises in, say for example, in a film business, they are of a different category, different nature. They have their different contracts, they have their different terms, stipulations. The persons of that particular calling or that particular profession, they were the best suited to decide those kind of disputes or bring about the best resolutions. And that is how the Shreni courts were there. Now you look at it and correlate it with the present day arbitration exercises, where you find so many of the arbitrators who are chosen out of the persons of the same calling or the persons well versed with the ethos of that particular profession, be it a contract, be it a film, or be it a regular merchant or different kind of classes of merchants, or be it the shareholding, whatever. The third category was the court of Gana. Gana was that when there was a collection of people, as we loosely understand to be a village. So a village court was considered to be the most suitable when there was a dispute. There may be a dispute going beyond the boundaries of Kul and Shreni both, and there may be a dispute, say, of neighbors who do not otherwise answer to the description of, well, the same family or the same profession. Village court was considered to be, and that was the court of Gan. The village court was considered to be the best court, and that is what our grassroots courts, in whatever form they are now framed or they are provided jurisdictions, were there. Until now, the courts were more or less of not having direct sanction from the sovereign. The interest contrast comes like this, that these were the court. Villages will be having their own. You are aware of the village panchayats or the village elders sitting together and solving out lot many other problems. We have expanded on that also. Now, these three were the courts which were otherwise not necessarily having the sanction from the sovereign. These were the courts of their own choices. Well, and they will have the resolution of dispute amongst themselves. Then the next three categories were the courts which were having the sanction from the sovereign, as the king used to be the sovereign. That's why the first court, the Adhikrata court, this was the court which was appointed by the king. That is what the Adhikrat is, that they have been given, they were empowered by the king. That's like the courts which you are holding today, as you are having a sanction from the sovereign. The sovereign has provided a particular sovereign, the people who have provided for a particular constitution, provided under the constitution there is a particular law. Under that particular law, the court is there. This court is having an authority, an empowerment, a power, well, flowing from the sovereign. This is the grassroots courts. You people, particularly dealing with the subordinate courts, the trial courts, dealing with all those kind of disputes which are coming to you with a sanction given by the sovereign that you are entitled to, well, resolve the disputes, you are entitled to deliver a judgment. Then there used to be a court called Sashit. That Sashit court used to be the king's court himself, as we know, and that was an interesting distinction. That king, otherwise as a sovereign, was having plenary powers. There are different powers. But apart from that, he was holding court also. He was a judicial officer also. That was king's court. That court was called Sashit court, where he was instructed in law by the other people also. And the final category was left to which was called Nrap. Nrap is again the Sanskrit word for the king. So king's court, king, so far as justice delivery was concerned, was the last one. Irrespective of all other five courts, in whatever manner they are doing or they were delivering, the final authority lay with the sovereign. That is where you will find that final authority in our jurisdictions at lot many areas are ultimately left to the person who is akin to the sovereign. Of course, when these are republics, well, when we are governed by our constitutions, the people are the sovereign, we can say broadly. But and yet, well, somebody would be the representative of the people. That is how we have the representative. But somebody like, say, the president, the final authority, who delivers finally the orders. Certain powers are, as you will find, are, well, reserved for the president. Is answering to the president is working on, of course, the will of the sovereign, but certain powers are left. Like, say, for example, a very loose example, like the power of pardon. All said and done, if you have delivered a judgment also, you have condemned a person to say that a person is finally to be condemned to death also. You're awarded even death penalty also. A power is reserved, finally, of pardon with the president. But that again correlates with the sovereign, because final powers were always required to be left with the sovereign. That is how these were the setup. What I am saying, friends, is this, that these were the setups of our legal history. They have been expanded, they have been redefined with the present day requirements, with the given day's requirements and present day requirements. We keep on evolving on them. But then, it's not that in 1984 only in India the Family Courts Act came. Of course, the Family Court Act came in 1984. But so far as Kul Court was concerned, that court was conceived in our yesteryears, in our annals, they are in our antiquities. We find these things were always there. They are the things for us, all of us, to ponder over, to enjoy the beauty of that, and to enhance our own capacities beyond that. Friends, I won't be taking much of your time now, but before closing on for the day. You have a long day to go with the learned faculties to be here, sharing their thoughts with you. There is one, since some of my colleagues I had been sharing that particular story, but with uh, our friends coming from Bangladesh, uh, I'm tempted to, and particularly my judicial officers, I'm tempted to share that story over again. It's just for all of us to always keep on reminding ourselves, nothing more than that. We have been given certain tasks, we have been given certain duties, we deliver justice, people look at us with hope, a lot many expectations, and with tremendous amount of respect. While we are doing it, of course, we keep ourselves always within the bonds of what is required of us to do. But still, there are certain things which we need to keep on reminding ourselves. That's for all of us to always understand, and that is depicted in the story of a great poet. Kalidas was his name. You must have heard his name. Of this area, Kalidas had been a great name as a great poet. This is a story I had been sharing, and I must have shared it with some of my colleagues, but I'm tempted to re-recite it over again. That Kalidas was a great name, great acclaimed person. Uh, Mahakavi Kalidas, he was the poet of the poets as he was known. It's a great name. So, and everybody, of course, was obviously supposed to be knowing about him. So he was one day. This is just a story, but when we light the lamps, well, this story again keeps reminding me, and I'm tempted to share with you. Kalidas was one day traveling through a jungle, traveling alone. He was to attend some kind of a program. So he was going alone. After crossing the jungle, he was feeling thirsty. It was a hot summer day. So he reached near a place where an old lady was drawing water from a well. So feeling thirsty, he went there and said namaste to the old lady and said, Mother, I'm feeling thirsty. Please give me a handful of water. The old lady said, Son, I'll give you water, but tell me, who are you? Now, this was problematic. This was hurting the great poet Kalidas. That here is an ignorant fool who doesn't know who am I. She is asking, Son, you tell me, who are you? Kalidas, great person, great learned man he was, but of course it was hurting. So he said, Mother, I'm a traveler. He said, No, you can't be the traveler. Sun and moon, these are the only two travelers who keep on traveling. You can't be the traveler. So tell me, who are you? So now it became a bit interesting. He said, Okay, treat me as a guest. I'm a guest. Then, no, you can't be the guest. Youth and wealth are the only two things which are guests. They never stay. They are the only things we can be called guests. You can't be the guest. So who are you? The story went on. Said, okay, treat me as a tolerant person. Said, no. Mother Earth and tree, these are the only two tolerant things in this world. You thumb on Mother Earth, you throw on stones on the tree, they keep on nurturing you, they keep on, well, helping you. You can't be the tolerant. Okay, treat me as a stubborn person. No, you can't be stubborn either. Hair and nails, these are the only two things which are stubborn. You keep on trimming them, they keep on growing. You can't be stubborn. Okay, I am a fool. No, you can't be a fool either. Fool is a king who rules without knowing the law. And another is the sycophant who praises that kind of a king. You can't be that. Kalidas knew it, that well, it was a checkmate for him. He was no match for the lady. He bowed down, touched her feet. As the story goes, of course, this is friend's story. As story goes, when he stood up, he saw Goddess Saraswati standing before him. What she said was this, and this is for all of us. She said, look here, son, you are a great learned man. You are a knowledgeable person, and there are hardly a person on earth who can match your learning. But there is something missing in you. That's why I had to come. When I asked you the first question, who are you? You felt offended because you are expecting that everybody must know it. And what was hurt was your ego. Please, son, never keep your ego with you. You do everything, you be the best one, you will always be the best one. But for God's sake, shun off your ego, never carry your ego. Friends, that particular story, whosoever we are, whatever we are doing, well, that story keeps on reminding us that, well, we all are faithful servants of the people, nothing more than that. There is nothing of ego to be carried by any one of us. I wish you all very, very best. Thank you so very much.
Thank you, sir. We are grateful, thankful, and blessed by your honors, guidance, and deep foundational knowledge sharing. Your Lordship, you are an inspiration that gives us courage. You are a craftsman who has built us. And I'm sure your magic wand will definitely help us in the task assigned to us. Thank you, sir. Coming together is beginning, keeping together is progress, and working together is a success. With that, escalating further, I would request Honorable Mr. Vijay Vishnoi Sahab, Mr. Justice Vijay Vishnoi Sahab, Judge Rajasthan High Court and Chairman, Working Committee Rajasthan State Judicial Academy for delivering the vote of thanks. Thank you, sir.
Honorable Mr. Justice Shri Dinesh Maheshwari ji, Judge Supreme Court of India. Honorable Mr. Justice Shri Sandeep Mehta, Administrative Judge and Chairperson, Rajasthan State Judicial Committee Academy. Honorable Mr. Justice Shri P.S. Bhatti sir, my brother and sister judges, Director Judicial Academy Shri Kamal Changani ji, officers of the Judicial Academy, judges and judicial officers from Bangladesh. Ladies and gentlemen, greetings to all. It is my honor to present a vote of thanks on this occasion on behalf of the Rajasthan State Judicial Academy. I would extend my heartfelt gratitude towards all the dignitaries who took out time for their busy schedules in order to be a part of this cognitive session. The Rajasthan State Judicial Academy conducts frequent training programs for adjudicators. Such sessions are conducted with the view to develop a practical sense of law and help the officers in precise application of law on practical aspects in the legal field. It aims to develop professionalism, the strong work ethics so as to ensure immaculate justice delivery. It is a matter of great pride that the Rajasthan Judicial Academy got opportunity to host and conduct training program for the members of the esteemed judiciary of Bangladesh. We welcome you, sir. Firstly, I would extend my sincere gratitude towards Honorable Justice Shri Dinesh Maheshwari Sahab for gracing the event with his noble presence. It was indeed a pleasure listening to the words of wisdom from my Lord. I am sure the gathering shall be immensely benefited from the wonderful address that we witnessed today. My Lord has delivered incredible judgments worthy of being followed. The address today contained all the elements and factors that an adjudicator must follow in letter and spirit in her service as a judicial officer. The gathering would be highly benefited from the valuable ideas and thoughts shared. Further, I would like to thank Honorable Justice Shri Sandeep Mehta Sahab for conducting this session and delivering a wonderful address. Lastly, I would thank all the participants who assembled here to make this session a grand success. I wish you all good luck and well-being. Jai Hind.
Thank you so much, Your Lordship. Now I request all the participants and the gathering to stand up for honor of national anthem, sir. Thank you. We'll be having a group photograph, sir.